issues to discuss.
36, this recording is back in session with the Honorable Raeigen Evans presiding. While court's in session, there'll be no reading, talking, eating, sleeping, walking around, or driving. When your name is called, please unmute your device if muted and give your full and undivided attention to the court. Once again, good morning, Your Honor.
All right, good morning, Mr. Petway. This is the people versus Ali Jabouk, ticket number SX4149268, count 1, violation of basic speed law, drove unsafe manner. Good morning, please say your names for the record.
Good morning, Your Honor. Ahmed Chiat on behalf of Mr. Ali Dabouk.
This matter was set for trial at 9 o'clock. It is now 10 o'clock. No officer has appeared. Do you have a motion, sir?
Yes, motion to dismiss, failure to appeal.
This matter is dismissed without prejudice. And you're all set.
Thank you, Your Honor.
Thank you.
And thank you again for your punctuality. It's always beautiful to have that. Thank you.
Thank you for your patience. Well, you have
Yes,
your
thank
one,
you.
so
Thank you, Judge.
have a good one.
Bye-bye.
All right, Ms. Robinson, you ready? Ms. Robinson? Was ready, then she left. Oh, there she is.
No involvement
I'm here.
contact with that person. No possession of any guns, weapons, or ammunition.
I'm ready, Judge.
Okay, Mr. Drain, you want to turn your video on? This is the people versus Nicholas Drain, ticket number P1281578, count 1, driving left center of street, and then count 2, open alcohol in a motor vehicle driver. Good morning, please say your names for the record. Mr. Drain, turn your video on. Starting with people.
Good morning, Your Honor. Good morning, Counsel, Mr. Drain. Shamika Horn on behalf of the people, P70303.
And good morning, if it may please the court, Sarah Robinson, P63181 for Mr. Nicholas Drain. Mr. Drain is present on Zoom, Judge. He lives in Manhattan, New York City, and he had to go to work. I believe he's on either the train or the bus. I think he's on the bus, but he is connected.
All right, Mr. Drain, say your name, sir.
Nicholas Drain.
All right, it's your motion, Ms. Robinson, so the court has received your motion and the very brief, so go ahead. Any argument, any additional argument as to your motion?
Yes, Judge, thank you. This is my motion to dismiss the case due to the police mishandling, destruction of evidence, and violation of due process of law. This applies, of course, to the misdemeanor charge, which is set for trial tomorrow. And in this case, my client was pulled over by Detroit Police Departments for a civil infraction. The car was subsequently searched. There was a bottle retrieved from under the passenger seat. This is per the video, allegedly containing alcohol. In the police video, the Detroit police order my client to touch the bottle and pour out its contents. I believe that this has deprived my client of the right to a fair trial. I'm relying on California versus Trombetta precedent. Is dictated by the principle, the holding, not the specific facts of the case. Very few cases have mirror facts of Supreme Court cases. In this case, had the police followed their procedure, which is to place evidence, tag it, and place it on evidence, we would have been able to have this bottle fingerprinted. We have been foreclosed from that. The defendant being able to observe or investigate the bottle is actually, it's just egregious. There are no cases where the police hand over evidence to a suspect and say, here, inspect this. It's for the lawyer to inspect, and more importantly, it's for the fact finder to inspect and to determine. And we've been deprived of that. We've been foreclosed on that point. By analogy, a drug case, a house is raided. Imagine if the police would say to a suspect, here, pick up that packet of cocaine and dump it down the toilet. This case doesn't turn on the bottle, it turns on the contents of the bottle. And Judge, we've been foreclosed. This turns on our ability to defend ourselves, for Mr. Drain to act to fully and fairly defend himself. This evidence has been destroyed by the police by the order. The police are the keepers of evidence. I reviewed the complete Detroit Police Department manual. There is no policy for destroying evidence at scene, including suspected alcohol. They didn't follow their own procedure, Judge. They destroyed evidence. It's unconscionable. I'm asking the court to dismiss this case. If the court is not inclined to dismiss this case, I'm asking for an adverse instruction that the video cannot be, those parts of the video and that show the alcohol be excluded at trial.
Any response, Ms. Moore?
Yes, Your Honor, the people are asking that this motion be denied in its entirety. Oftentimes with defense counsel, they want video, they want discovery, they want until it is not in favor of their client. Here we have a video and we have witnesses who can testify at trial as to the contents of that bottle. Additionally, there's circumstantial evidence here that's pretty strong, where this bottle contained, it was approximately a certain amount of alcohol that contained a certain amount of no alcohol, and which proves that this bottle was also unsealed. The people are simply trying to prove that there was open intoxicants in a vehicle. And we have witnesses who can testify as to that fact, which is an old school thing, actually, because witness testimony has been brought here through common law. Addition to, I don't know of a policy, especially in a public health sense, where the police officers maintain and keep and tag a bottle of alcohol. It's also our argument that he had the opportunity to inspect it. Whether his fingerprints were on it, I think that's immaterial. The matter is that he was transporting open intoxicants in the vehicle. The people will also cite, for the record, Your Honor, Arizona versus Youngblood, 488 U.S. 51, 1988, wherein Supreme Court Justice Rehnquist held that failure of the police to preserve potentially useful evidence was not a denial of a due process of law, absent defendants showing bad faith on the part of the police. We believe the video should be entered to show that there was no bad faith at the scene. Actually, they gave him much deference. There could have been further investigation, but it was not. So the people ask that this motion be denied.
All right, any rebuttal arguments since it is your motion, Ms. Robinson?
Judge, I would just say that the police actually suppressed this evidence, and that's up to the judge. The judge decides what evidence comes in at trial, not the police on the street. And this evidence should be there for the fact finder to inspect. I would ask the court to dismiss.
I'm assuming that during trial, if trial happens, that the people would make an attempt to show the video. I'm assuming.
That's correct.
Okay.
And the people have shared this video with Ms. Robinson and her client.
Okay. It doesn't seem like the police have mishandled mishandled the evidence. It seems like it appears that the people can still present evidence based on testimony. And it really seems like it just becomes a question of fact as to the contents that were in the bottle. So I don't think that your client is prejudiced in any way if because they don't have the actual liquor bottle. I don't think that this has been a violation of this due process based on having the defendant, Mr. Drain, pour the bottle out. I'm not seeing it. So it looks like it's just really just a question of fact for the fact finder.
And it's my understanding that this is a jury trial, Your Honor.
All right, well, that would be for the jury to decide.
All right.
I just don't think his due process has been violated based on the police officer having him to pour the contents out of this bottle.
All right, well, I guess they destroyed the evidence. They ordered my client to destroy evidence, Judge. So that's where I would say that it's more than pouring out. That's what this whole case is about. It's about the contents of this bottle. All right, Judge.
All right, so we're still scheduled for tomorrow morning.
Yes,
Your
I
Honor.
do have, this case was originally scheduled for 1:30 p.m., but I do have about 3 or 4 Zooms in the morning, which is going to make it very choppy.
We'll work around it.
Okay,
So, and Your
all
Honor,
right, thank you.
It's in person, correct?
It is in person, and I'm assuming I know we lost your client, but I'm assuming he intends on being here tomorrow for the jury trial, correct?
I hope so, Judge. I hope so. Let me call him.
And then we're also have a bench trial scheduled on that Daughtry. Yeah.
All right, so we'll see you tomorrow.
Okay, thank you, Ms. Robinson.
All right,
Do
thank
you
you.
have
See you
my,
tomorrow.
you have my telephone number?
I don't think so. I
I'll
might.
shoot it over. Yeah, my cell phone. I'll shoot it over to you.
All right, bye-bye.
Okay, thank you. Good job.
You're ready on Mr. Roberson?
I'm ready on everyone, except for we need one offer, I think, Your Honor.
Oh, I have you're here, I'll send an email to she.
And I also sent her the message,
Tamika, if you could go to room 16, give my permission to talk to the defendant, and he can show you his documents and explain what's happening.
Okay.
Thank you.
Okay, so I just sent something to Ms. Coker. All right, thank you. This is the People versus Emmanuel Roberson, number SP 1266813, count 1, no insurance misdemeanor. Good morning, please say your name to the record.
Alan Soroki, P37441, appearing on behalf of the defendant. What's your name for the record, sir?
Emmanuel Roberson.
Yes, Your Honor, defendant wishes to accept the offer of improper plates.
Raise your right hand, sir. Do you swear or affirm to tell the whole truth and nothing but the truth?
Yes,
Put your hand down. You've had an opportunity to speak to Mr. Soroki, the attorney, in private about your case and your rights.
yes,
Has anyone threatened you, forced you, or promised you anything of value in exchange for your guilty plea today?
correct.
You're pleading of your own free will?
Yes,
No, I'm sorry. Has anyone threatened you, forced you, or promised you anything of value in exchange for your guilty plea? Has anyone threatened you, forced you to?
no,
You understand that by pleading guilty, you're pleading guilty because you're actually guilty?
yes,
You understand that by pleading guilty, you're waiving your right to trial?
yes,
And knowing that you're waiving your right to trial, you still wish to continue with your guilty plea?
yes, ma'am.
All right, so the court,
Satisfied, Your Honor.
the court's gonna direct your attention to October 20th, 2021 at 6:46 p.m. Oh, you're satisfied with the advice, right? Thank you, Mr. Soroka. On that date and time, were you at or near Cashew and Raeigen in the city of Detroit?
Yes,
Were you driving a 2015 Ford vehicle?
yes,
And did you not have insurance on that vehicle?
yes. No, I did not.
Okay, you satisfied, Mr. Soroka?
Satisfied, Your Honor.
All right, the court's also satisfied the factual basis will amend the count to improper place. We'll proceed to sentencing. There's a $200 fine. Mr. Roberson, can you pay that fine on March 8th?
On March 8th. Can I get a little bit more time? I'm in school right now. I'm taking my CDL at this moment right now. But in the beginning of March, I get out of school and then I will have a job lined up. So can it be at the end of March, maybe?
Yes, we'll do April 5th.
All right, all right. Okay,
So you're all set.
all right, thank you.
We lost you, Mr. Drain, but your motion was denied, so you have trial set for tomorrow.
Okay, thank you.
Do you know you have, it's in person, Mr. Drain?
It's in person, you
Yeah.
gotta be here.
I'll be here.
Okay, and Judge, could you move your camera up closer?
Oh, I'm sorry.
But we'll see you tomorrow, Mr. Drain.
All right.
Alonzo's iPhone. I need you to turn on your video and give me your name. Alonzo's iPhone.